Are you facing tough financial decisions, trying to decide if you should declare bankruptcy to avoid a foreclosure, or whether you should wait for the foreclosure to happen and then declare bankruptcy? This can be a very scary and confusing time. But I want to share with you some information that may give you an insight into what path you should take. Hi, I'm Jim Keaveney of the Keaveney Legal Group. We are a New Jersey and Pennsylvania-based law firm that focuses on foreclosure defense and bankruptcy. We regularly counsel our clients on the advantages and disadvantages of both bankruptcy and the foreclosure process, and we help our clients find ways to maximize their opportunities through well-thought-out legal strategy. Join me as we discuss this topic today. When it comes to declaring bankruptcy before foreclosure, whether or not you should do it really depends on your particular goals. If you want to delay the foreclosure for a while because you believe you have no other options for staying in the home, then a bankruptcy might be a good way to do that. Also, if you want to avoid the possibility of a deficiency judgment against you after the foreclosure, then a bankruptcy could wipe out that obligation. If, on the other hand, you'd prefer to keep the property but cannot afford the current monthly payments, you may want to explore other options. For example, you may be able to obtain a loan modification without going through bankruptcy at all. You may be able to obtain a loan modification and avoid the foreclosure process altogether. This could dramatically reduce your monthly payments and allow you to keep your home and your investment. Of course, you might be able to do that after your bankruptcy as well. But sometimes the bank asks you to reaffirm the debt that you had discharged in the bankruptcy. A reaffirmation means that you agree to pay all or a portion of the debt that might otherwise have been discharged in bankruptcy. As a result, it might be wise to pursue a loan modification before filing for bankruptcy, since the modification may remove you from the circumstances that put you into the bankruptcy, and it can keep you from reaffirming a debt that otherwise might have been discharged, simply so you can keep your home. That way, if you still need to pull the safety valve of a bankruptcy, you can safely count on the mortgage debt being discharged as well. Another important consideration is upkeep of the property. Many people believe that if they declare bankruptcy and move out of the house, their obligation is over. However, in reality, the owner remains obligated to maintain the property until title transfers to someone else. As a result, you could be held liable for such things as code violations, homeowners association liens and penalties, and other upkeep expenses related to the property. Therefore, you must carefully consider what you will do with the property before deciding whether bankruptcy is right for you. Every case is different, so you will need to speak to an experienced attorney to get the best advice on your particular circumstances. Here at Keaveney Legal Group, we are dedicated to helping those facing foreclosure and bankruptcy. We understand the pros and the cons of both systems, and we'll be happy to assist you in determining the best course of action for your particular situation. Feel free to give us a call at 1-800-219-0939 or email me at jim@keaveneylegalgroup.com. I'm Jim Keaveney, and thanks for watching.